Something pretty huge just happened for every citizen in the European Union. A powerful new right has just been created, and it's a tool that's designed to pull back the curtain on some of the most important automated decisions being made about our lives. Today, we're going to break down your new right to an explanation under the EU's landmark Artificial Intelligence Act. So, let's imagine this for a second. You apply for a really important loan, and you get rejected. The reason? An algorithm decided against you. And for years, that was it. A dead end. Just a big black box you couldn't really question. But that's all changing. We're going to explore what you can do next, and the power you now have to demand real answers. All right, so here's our roadmap for this explainer. First, we'll look at the specific AI decisions this new law actually targets. Then, we'll unpack the right itself. After that, we'll talk about what an explanation actually has to include, and we'll also cover the crucial limitations. We'll wrap things up with a practical guide on how you can take action. Okay, first things first. It's really important to get this right. This law doesn't cover every single AI you bump into. The law is laser-focused on what it calls high-risk AI systems. So what exactly is a high-risk system? Well, think of it as any AI whose decisions can have a serious, real-world consequence for you. We're not talking about a music recommendation algorithm here. We're talking about systems that can literally change the course of your life. And yeah, these examples really hit home what we're talking about. An AI that filters you out of a job application pool, an algorithm that denies you a mortgage, a system that decides your social security benefits, even software used in medical diagnoses or by the police. These are the high-stakes decisions where transparency is absolutely essential. So how do you fight back when one of these systems makes a decision about you? Well, the answer is in something called Article 86 of the EU AI Act. This is the key. This is what gives you, the citizen, the legal standing to demand clarity. And what's so interesting here is that this right wasn't just pulled out of thin air. It was actually forged through some pretty intense debate. If you look at that top row, the first proposal back in 2023 was incredibly strong and broad. But as you follow the timeline down, you can see how negotiations led to a compromise in the final law, narrowing the scope to try and balance our individual rights with business interests. This slide really lays it all out, side by side. The scope was tightened up from this broad idea of socioeconomic well-being to only legal or similarly significant effects. But the most critical change, and I mean this is huge, is on the right. The requirement to include the specific input data used in your case, it was completely removed. That was a massive concession, and as we're about to see, it has some major implications. Okay, so if they don't have to give you your specific data, what do you actually get? What does a clear and meaningful explanation really look like under this law? So, the law says the explanation has to cover two main things. First, it has to be clear about the role that AI played. Was it the only decision maker, or was it just one tool a human used? Second, it's got to outline the main factors or parameters the system looked at to come to its conclusion. And we really have to hammer this point home because this is without a doubt the biggest catch. It's a critical limit on your power to challenge a decision. Think about it. Without knowing the exact data they used, how can you check if the AI relied on a wrong credit score or misunderstood your job history? It's the biggest question mark hanging over the true power of this new right. All right, so this brings us to the fine print. Because like any legal right, this one comes with some specific exceptions and conditions where it might not apply. So for example, your right to an explanation can be limited for something like national security. It also doesn't apply if another EU law, like the GDPR, already gives you a similar right in that specific situation. The key takeaway here is that this new right is meant to fill in the gaps, not to replace protections that already exist. And look, a government or a company can't just say national security and call it a day. Any exception has to pass what's called the proportionality test. This is a pretty high legal bar that basically means if they want to limit your right, they have to prove that it's absolutely necessary and that it's the least intrusive way to achieve their goal. Okay, let's get practical. You've gotten a decision from one of these high-risk AI systems, you feel it's unfair, and you want to use your right. What do you actually do? This final section is your step-by-step guide. It's actually a pretty clear four-step process. Step 1, you make a formal request to the organization that used the AI. Step 2, you review what they send you. If it's not good enough, not clear, or not meaningful, then you can escalate. Step 3 is lodging a complaint with a national watchdog.
And if all else fails, your final option is the courthouse. You're probably wondering, who is this deployer I'm supposed to contact? Well, it's just the entity that used the AI to make a decision about you. It could be the bank that processed your loan, the company that screened your job application, or the government agency that handled your benefits. They're the ones on the hook to respond to you. And what if you need to take it a step further? Your point of contact is your National Market Surveillance Authority, or MSA. Every single EU country is going to have one. You can think of them as the official referees for the AI Act, and they've got the power to investigate complaints and make sure everyone is playing by the rules. And make no mistake, filing a complaint with the MSA can have some serious consequences. They can force a deployer to give you a proper explanation, they can impose some hefty fines for breaking the law, and in the most serious cases, they can even order that the high-risk AI system be pulled from the market entirely. So, what's the bottom line here? It's this. The days of the AI black box just spitting out a no with no recourse, well, those days are starting to end. For the most important AI-driven decisions in the EU, you now have a legal pathway to demand transparency and hold decision-makers accountable. And that leaves us with one big question to think about. This new right is, for sure, a massive step forward. But is it the final answer for AI accountability? Or, especially with its limitations, is it really just the first necessary step on what will be a much longer road to making sure AI serves all of us fairly and transparently?